Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 visa, specifically the sort of DIY or do-it-yourself K-1 visa. What are we talking about when we're talking about this? Well, this is a topic I've been always rather neutral on. This over a decade I've been doing this, and people kind of ask me, "Oh, does it bother you that people do it on their own?" Not particularly. People hire me and hire our firm to assist in U.S. immigration matters for all sorts of reasons. Some people find the process a bit overwhelming. Some folks just don't have the time to undertake it all. Everybody's reasoning for retaining an attorney is different. But that being said, there are plenty of people who undertake the process in a sort of a DIY fashion, in a do-it-yourself way. And I've never had really any opinion one way or the other. That's their right. It is possible to do a pro se filing for a K-1. But that being said, as noted in some previous videos on this channel, recent policy changes at the USCIS are resulting in what I think is going to be something of a sea change in how visas are adjudicated, specifically with respect to denial of visa applications or visa petitions. And what I mean to say is there's been a change in the policy by which USCIS will issue what's called RFEs, or requests for evidence, whereas at one time, USCIS was practically required to issue an RFE in almost every case. It's now no longer required that an adjudicating officer issue an RFE, or request for evidence, if the eligibility is not clear in the initial filing. What I think this is going to result in is a number of denials being issued sort of out of hand. And I think you're going to see this happen to a lot of do-it-yourselfers here in the future. So the reason I'm making this video is not so much to discourage folks from doing it themselves. It's so that people understand what they're getting into, especially in light of this new policy change. So understand, moving forward, as of September 11th, 2018, and the rescission of what I call the no possibility doctrine. And I strongly recommend, there's a few videos going back on this channel, 2 or 3 actually, as of the time of this filming, where I specifically discuss the RFE policy changes. Basically, for purposes of this video, what needs to be understood, at one time, it used to be USCIS officers could only issue a straight denial, like an out-of-hand denial, if there was no possibility that the couple in question was eligible for the benefit at hand, in this case the K-1. That has been rescinded, so if on its face it has not been proven that the couple in question is eligible for K-1 benefits, well then it is possible that the adjudicating officer just go ahead and deny the petition. Do I think they're going to do that sort of wantonly? I doubt it. I think they're probably going to continue issuing RFEs, but I do think it's very likely they're going to issue them in fewer and fewer circumstances. So for this reason, do-it-yourselfers should be very aware that the policies have changed, and it might be a good idea to more heavily scrutinize one's filing, or possibly contact a legal professional at the very least to get some advice about how best to proceed with the K-1 before undertaking a process that may waste one's time, money, and resources as a result of filing a deficient petition for K-1 fiance benefits.